Okay, welcome to a special edition of Exposed. Today we had our restraining order hearing. Tomorrow we get a decision on whether or not constitutional rights will be suspended and the actions and allegations made in there merit a restraining order of permanent nature. I can tell you this because it's public record and I looked through my evidence that information that was put into today's hearing has to do with the law about posting information about police officers. I can now tell you that people in the dais and people that have heard the tape recording of the last about 25 minutes of the hearing know exactly why this restraining order was sought. And it has nothing to do with imminent harm. It has nothing to do with making threats, especially by me. What I can tell you is this, is that I can address what I addressed in the hearing today. Mr. Martin, in his comments on the stand, I took an extra long time with him, so we took care of that. I can also tell you that there was concerns about Mrs. Vance, Mrs. Ringen, comments made, discussions talked about, and things like that. The judge did not quash your subpoenas. I didn't have time to call you. Okay? I will stand behind what I said. Okay? I will stand behind November 9th. Now, in the interim, I will probably have to file an appeal to state court because I'm not going to ask for a motion of reconsideration if I lose, and I just don't work like that. I can tell you this, nobody threatened anybody, at least from the perspective of this complaint. Okay? So that's on the books. I can also tell you, Mrs. Ringen, that your statement to me about Woodman Hills paying legal fees to take me out is 100% accurate. And if you other 4 board members think that you're going to stand behind what's going on here and it won't affect you, no. Okay, today I was going to use Mrs. Ringen as a rebuttal witness. I brought up the recordings I had, but because I never got a chance to call her, I couldn't do it. And that's all right, because at least she didn't run away, okay? And we filed the motions, and she was going to be heard by phone along with Mrs. Vance, because they didn't quash those subpoenas. Okay, when the testimony comes out, and I'm going to find a way to get that testimony out, one way or the other. If that means I have to have somebody set up another website under another name close to this one to post it, it's getting posted. But I can damn well guarantee you that today, in that courtroom, I did not threaten the plaintiff. And what you think you knew about what was going on had nothing to do with imminent harm, based on what I heard today. Now the judge, he's a good judge, but as I said early on, he's a judge for the cops. So I'm going to end up, if I have to, I will be filing an appeal on this. And I can tell you that Mr. Bendelow sat in that room for 3.5 hours charging us buku bucks, only to find out that the statements made about legal expenses expended by this district to come after me were verified today. Your money wasted to come after me. I wanted you to know that, okay? November 9th, the recall will start, notwithstanding tomorrow's decision, okay? And then the appeal gets filed to district court, all right? Because what happened today was, if I'm usually pretty good about this stuff, the judge wasn't being so nice to me, and that's okay. Sometimes they are and sometimes they're not. But I can tell you this, I can tell you that what you thought you knew about this case, you don't know, okay? And I freely admitted in the courtroom that what's on my website that I posted it, okay? Because I stand behind what we post. But, again, didn't threaten anybody. That's all I had to worry about. And when the rest of it comes out, because I'm going to order the transcripts, that you, the board, or the other part of the board, really start to consider what I just learned today, okay? Which is, I knew a long time ago that this district expended hundreds of thousands of dollars to take me to court and involve themselves in trying to take my home. And the judge found out about that today. I'm Mr. Pace. Mrs. Ringen and Mrs. Vance, You do the job that you were elected to do, and don't worry about what you filed with the court. Because when the time comes, Mrs. Ringen, as I said today in that courtroom, the things you told me were to fix the problem. Okay? And I'll get to the Vance part of it later, but you'll find out exactly what I said about you when the time comes. But I made it very clear that you two were trying to fix the problem. And I was not near that district office when you went in there to dismiss someone who actually wasn't even there. That's it. And that restraining orders are for people who are in imminent harm. And as said today, doesn't apply to me. Anyway, that's all you need to know. We'll see what happens tomorrow. And then from there, we either have to file an appeal or we don't. But either way, November 9th, my name goes on a recall, my name goes on the books, and this time, I guarantee you, after what Matt did with the last recall in a hearing you guys never knew about, the ARC, the OAC ruled that my recall, or any recall that my name was attached to one way or the other, should have never been thrown out of court. And that's something else we learned today. We also learned today that Dave Stiver knows what the fuck he's talking about, and as he said in the testimony, just because you're an elected official doesn't mean you can use your job to seek protection from being criticized or anything said about you and go that route. It doesn't work like that. You don't get to do it. I'll be looking at filing my brief if I need to and appealing to state court if I have to. I will tell you this. Mr. Bendelow knew what was going on, and that's why they wouldn't turn over the records to me, because Mr. Bendelow knew that this district had expended a ton of cash to take my house and to defend against a lawsuit that they claim they weren't a part of. That all changed today in testimony. I'm Mr. Pace. Think I'm full of shit? Check with the other side.